So I wanted to do an update quickly. This just because they did finally release the numbers for the end of 2024, and then Lady Feingold had a presentation during the AxeCon where she also did a summary of things that are going on with ADA litigation. So the numbers for the lawsuits haven't really climbed since 2018, and they're at plateauing around 4,000. So that's about 100 lawsuits filed per week. We did have a little bit of a drop from 2023 to 2024. So it seemed 2023 was higher in the amount of lawsuits at almost 4,600. So 2024 ended with about 4,000 as well. But still, it's a significant amount and definitely much more than we had just a few years ago. And again, desktop websites are still the primary target. Mobile apps consist of about 1% of the lawsuits. Still, the focus is on fixing websites, since so many websites are not compliant.
Hmm.
And small business litigation is increasing. It's about a third are small businesses, which their definition of small business is under $25 million in revenue. And two-thirds of the lawsuits hit larger businesses that make $25 million in revenue or more. E-commerce continues to be the leader in what kind of industry is targeted in litigation. 77% of lawsuits hit e-commerce. Businesses, other high industries would be food and restaurant industry and also education. And surprisingly, Florida is rising. It beat California as the second most highest state with litigation. New York is still number one. A lot of cases are filed in New York, but Florida is coming up there, which was to me a little bit surprising, and it's beating out California at this point. And so Lady Feingold spoke at AxeCon earlier this year, and she emphasized the idea that digital accessibility is a civil right. The recent attack on disability is really affecting the civil rights of a group of people here in the United States. There's a lot of fear and uncertainty and frustration within the community with the layoffs and legal uncertainties. A lot of people don't know what to do. And There is some resistance that's possible legally that can help folks that have been laid off and things. There's still cases where people are trying to fight back on some of these layoffs. And the main way to overcome any challenges is to find your community. And there is a big community out there with people with disabilities supporting each other at this time. And the laws that exist today are a result of decades of advocacy. So it's really frustrating to a lot of folks that these laws that have been in place for a while and took a lot of time and effort to put there are under attack. And she did summary of some of the laws that are out there, the framework for digital accessibility. So we of course have federal laws, and that would include the Americans with Disabilities Act, Section 504, Section 508, federal regulations, policies within different federal agencies, then state and local laws. And then, of course, the United States is also being affected by global laws. ADA was essentially an anti-discrimination law from 1990, and it applied to state and local governments, private sector, nonprofits. So if you are making digital content inaccessible, it is a discriminatory act. And the DOJ confirmed in 1996 that the ADA requires web accessibility. It applies to the internet. And in 2024, the ADA Title II was updated. It was the update of the web and mobile rule. It covered state and local governments. It enforced the WCAG 2.1 AA standard on state and local government websites. And the compliance deadlines were set for 2026 to 2027. Other laws that are out there, Section 504 basically makes it so that you can't discriminate if you receive federal funds. This affects healthcare and education primarily. And then Section 508 is about work in federal agencies, that federal agencies must use accessible technology and provide their workers the ability to do their job. There's also the CVAA, the communications that applies to video gaming accessibility and telecom. And there's a health tech accessibility section 1557 as part of the Affordable Care Act. And then also the Air Carrier Access Act is used to regulate the airline industry, making sure that their websites are accessible as well as kiosks. And she emphasized that there are 13 federal court circuits that interpret the laws differently. And there was a recent case where the state of Louisiana was sued over inaccessible websites. And the key takeaway from this was, even though we just talked about how in 2024 they updated Title II, state and local governments must make their websites accessible, and they put forth these deadlines, 2026 and 2027. The situation was that Louisiana was sued now over their inaccessible website by someone that was attempting to use a website and couldn't get the information. And the argument was that the deadline hasn't come yet, but basically they lost the case. You need to get your website, if you work state and local government, together now as soon as possible. So even though those deadlines are projected out to 2026 or 2027, depending on the size of your locality, if someone chooses to sue you now for not meeting the regulations, that you might basically lose the case, because that's what happened in the state of Louisiana. So now Louisiana has to get their website together as soon as possible.
Wow.
And there's a lot of concern that federal laws and regulations are under risk right now because of DOJ rule changes, congressional efforts to limit the ADA, the 17 state lawsuit that's challenging Section 504. And if you, Judy Human, she actually recently passed away, but she was part of a sit-in protest in that way back when, which led to the Section 504 becoming law. And that was the subject of a movie called Crip Camp, if you're interested in watching that. So it was about how this law came about and how the people protested to bring it about. So it's sad that it's being challenged now, given the amount of effort that advocates had put into getting the law in place. And the reason it's under threat is because the preamble references people with gender dysphoria as being considered disabled. The effort is trying to change the preamble because of the concern currently about transgender issues, but a lot of people are also arguing that the whole of Section 504 is unconstitutional. So if you want more information on this, I can send you the link to the Disability Rights Education Defense Fund, which is trying to help fight against these lawsuits. If people that live in states that are involved in the lawsuit, they would have some weight to call their representative to withdraw their state from this lawsuit. And globally, there's many U.S. companies that will be affected by new laws coming about in other countries. So the European Accessibility Act will start restricting market entry for products that are not accessible. And again, their deadline is like June 28th, 2025. We'll see how well companies have been trying to meet this deadline. And there's also a new law in, it's not super new, it's been there, but so there are laws now in India, Rights of Persons with Disability Act in India. So there's been progress in different countries. And that will affect any company in the US market that is attempting to be a global company. They have to think about their global markets and comply with laws overseas. And if people choose to ignore the law, what are the potential penalties? Legal action can force them to make the fixes. The DOJ can fine penalties up to $150,000, and then private lawsuits, you may have to pay damages as well as the attorney's fees. And in the case of the EAA, and global penalties can include fines. You can be banned from selling your products in Europe, and sometimes even jail time in some countries. And these are some big cases that have affected how things have been shaped. UNC Healthcare had to make accessibility improvements to their digital access. They had to pay $1.1 million in attorney's fees. There's been many higher education cases, and the big one was Los Angeles Community College. They kept on fighting the lawsuit, but they lost, I think, twice. They lost the lawsuit and they lost on appeal. The sad thing about that is that the people who brought up the lawsuit, in the end, the fix didn't come in time because courts are slow. So they ended up, their college experience was subpar because they didn't have the right materials to do the work because the college wasn't honoring, accommodating their disabilities. So they've since, I think, graduated, but they didn't get the fix in time. But hopefully it will help other students that go to these schools that the universities make changes. And then there are a lot of corporate cases out there. Questman, LabCorp, and CVS have all been sued over their kiosks. So kiosks are becoming more prevalent, doctors' offices and medical facilities. And if the kiosk is inaccessible, there needs to be a way to get around that. And then there was a big snafu with the California park system. They hired a web development company to create their website. And the company actually stated that the website was accessible, but it was false. And they had to return the money that they were given to do the work. So again, you have to be careful in the contracts that you make. So they had to return $2 million back to the state as a result of
Wow.
failure to make the website accessible because it was part of their contract and they didn't deliver what was in the contract. And then there's been overlay cases, so Accessibility and Userway are both facing FTC fines for misleading marketing, and then there's class action lawsuits as well, and those haven't been resolved yet. Yeah, so again, 4,000 suits, mostly targeting websites. 1,000 of the lawsuits were against companies that were trying to use overlays as their solution, but it was inadequate. And SiriusXM is also facing a lawsuit for a lack of transcripts on their podcast information. So, what are some risks now with what's going on with our changes in government? So, the DOJ and other agencies may stop being as involved in investigating complaints. So, it's really important for states to be the enforcers at this point. The New York Attorney General since 2009 has been involved with lawsuits against companies that are have websites that are inaccessible, and state officials can be pressured to step in. And what can you do? Basically, businesses can proactively fix barriers before any sort of legal issue arises. You can be an advocate for accessibility friendly policies. You can keep abreast of these legal challenges, stay informed of what the result of the lawsuits are and how that affects what laws are out there, and continue to support the disability community enforcement efforts. And again, digital accessibility is a civil right, and the ADA at this point is not going away. Enforcement and advocacy will continue to shape what rights are out there. I was actually reading about a Supreme Court case where the DOJ has actually continued to be in the case. This has less to do with digital accessibility, but is for disability rights in general. Is a family with a child with disabilities. They moved from Kentucky to another state. I don't remember which state now. And that school system hasn't provided the same level of accommodation for their child. And they feel like the education that the child is receiving is inadequate as compared to where they were. And so they sued. And this case has gone all the way up to the Supreme Court. And the DOJ is actually part of the case and they've stuck with it, but it
Wow.
hasn't been decided yet. So the question is basically the state is saying that they haven't proven that it's an undue burden on them. And I guess the family arguing why do they have to prove that as a family with a child with disabilities, that the barriers for them are overwhelming to get access to accommodation, that they keep on having to prove X, Y, and Z to get the basic care for their daughter in the school. And it shouldn't be like that. It shouldn't have all these barriers. That's their argument. So we'll see. I think the child has a rare and unusual form of epilepsy. So they require an extended learning day as well as a late learning day. They can't start school early, like most kids start in the morning. So they were able to accommodate where the school day doesn't start until noon. But that also means that the child needs to continue to have education through the evening. And I guess in Kentucky they were provided that, but the state doesn't want to provide. They claim that they don't have the resources to provide all this additional education going into evening hours. And as a result, the family is saying that their child is getting behind education wise and it's not fair. And so they're arguing about it. The state argues that they've provided as much accommodation, they've changed the school day for them, and they've done all these different things, and they feel like the family's not working with them enough. And the family's argument is the school is not doing enough. So anyway, it's going to the Supreme Court, and
Yeah.
they heard arguments, but I don't think there's been any decision on the case yet.
And then at the same time, just like with the college case, the student is still suffering and it might not even get settled in time for them to actually benefit from the result.
Because usually the court is fairly slow. I think the other cases, the Harvard, if I remember, I think these all of these, Harvard, MIT, they were about like accessibility for video. I think it was like a lack of closed captioning or transcription, things like that.
Okay.
I believe that these cases were all that. And the kiosks are a big thing now because the kiosks, they're popping up everywhere and people aren't even thinking about it. Oh, yeah, we have to make these things accessible. And
Yeah. And I've run to that here too. In some of the offices, they don't even have a person at the desk anymore. You just have to go to the kiosk.
right.
And that accessibility, it's interesting how it interfaces with different sectors like that. And there's a large retirement community here, basically. The population, like over 50%, is retired and not as tech savvy to begin with. So whether or not it's an accessibility issue, it's just a whole tech literacy issue too. And they fall into that same space where you're forced to use this technology that you can't really use that well.
Yeah.
Wow.
So that's where we are with litigation, ADA litigation.